Okay, good morning, everyone. My name is Natasa Lalovic Maric. I'm a partner at Wolf Theiss. And today I'm very pleased to welcome you on this webinar actually, that is organized jointly by Wolf Theiss and my esteemed colleagues from Aon, Benoit, Nathan, Rebecca, and George. We will wait for additional 2 or 3 minutes to enable everyone to join, and then we will start with our webinar and presentations. Okay, I think that we can start. So welcome again on this webinar. As you see from the title, Startups and Tech Investors Beware. We have picked a topic which appears to be rather hot at the moment, given the fact that despite all the crises that we are facing on the political, economic level and all these health issues that we have been facing recently, the pace of mergers and acquisitions in IT sector appears to be rather stable. And we have just recently witnessed the major transaction acquisition of Twitter by Elon Musk. Before that, Microsoft was very much active in acquisition of artificial intelligence companies, video game companies, and even in a country which is rather small like Serbia, approximately 10% of GDP is still derived from ICT sector. So we have decided to discuss some of the issues that are very much relevant for each startup and a tech investor operating in IT industry, as well as for other natural and legal persons who do handle and deal with IP assets. So we hope that you will find this webinar useful and that we will provide you some guidelines when it comes to how to avoid some of the common pitfalls in operation in IT industry and in business transactions. So in the first part of this webinar, we will focus on some legal issues. I will be presenting these legal issues, and then we will focus on the issues that will be presented by our colleagues, which deal with the different types of due diligences. Just a technical information, if you have any questions, please use the chat box and address all questions to me, because I will be also moderating the entire webinar. And then at the very end of the webinar, we will try to answer as many questions as possible. So let's start, because we have not that much time available. So on this slide, you can see a very simplified lifespan of a typical startup. And this slide basically shows you what we will be discussing in the first part of the webinar. So everything starts with an idea. If you have an idea for an app or for some product, you might be on the verge of creating an IP asset. And as soon as you do have an IP asset, I guess if you want to deal with it in a serious manner, you need to start thinking about incorporating a company, establishing a startup. Once you establish a startup, you will deal with IP protection, and we will talk a little bit about that. And as you grow, then you will need to deal with IP planning and IP management. And this is another thing that we will cover in the course of this webinar. Now, as you grow big, and as you grow, before you exit and make big bucks, as we say on this slide, or before you join your forces with other serious investors, there will be activities that you will need to take care of, such as due diligence, valuation of your company, negotiation of the SPA, and hopefully signing and closing of the transaction when this payoff time will come. So let's start with the first topic, and this is a little bit about IP assets. So what are the IP assets? IP assets are non-tangible property, which is associated with a specific economic value, which may exist at the moment or is coming, once you grow your IP assets. In general, they're considered creations of mind and they're granted protection basically everywhere in the world. And on this slide, you can see what are the main laws and regulations concerning the major IP assets that we deal with in practice, such as copyrights, trademarks, patents, designs, appellations of geographic origins, and trade secret. All jurisdictions in which we operate do have local laws and international treaties and conventions which apply to protection, and all these regulations give us guidance as to how to protect and how to deal with IP assets. Now let's see how IP assets are protected. Namely, the main thing why you want to protect your asset is basically to enable yourself to be the exclusive user of these assets, or to actually charge fees to others to be able to use your assets, and prevent others who do not pay these fees to use them. There are different means of protection of IP assets. The main mean of protecting your IP asset is through registration, and such registration is done through local offices or some regional or international law offices. Of course, before you start the protection procedure, you need to make sure that your IP assets is actually valid enough to be protected, that there is nothing else, that is similar to your IP assets that would prevent such protection. Protection is very much important, given the fact that lack of protection or lack of adequate protection of IP assets may result in permanent loss of your right to use these assets, or can lead to some litigation, administrative proceedings, or some unpleasant, discussions with other parties. And it may, of course, lack of protection may hamper the overall potential of your company to grow. Just think of a situation in which you have been, for example, using a mark to trade certain services or sell your goods, but you have not actually protected the trademark. And then somebody else comes and does protect that trademark. That can make your life pretty difficult, because that person can instigate infringement proceedings against you, or you will be forced to instigate some administrative proceedings in order to prove that the other person has been acting in bad faith and was not permitted to actually register its trademark. So all in all, you need to actually make sure that whatever you need to use is properly protected. And here you can see on this slide a list of common pitfalls that actually negatively affect operations of the company and the overall valuation of the company. And all these pitfalls generally arise out of insufficient understanding of the relevance of IP protection, failure to make such protection, then failure to actually procure that you have a very clear ownership chain over the IP assets that you claim to own or use, and we will talk a little bit later about that, and poorly drafted IP agreements. Now, if you recall the first slide that we have shown, we said that actually you have an idea, you protect that idea through a company, and then as the business grows, you need to start IP planning. Now, what is IP planning? This is actually a group of actions that you need to undertake to protect and to manage your IP assets, given the fact that all of that will stimulate the development of your company, the maintenance and exploitation, as well as acquisition of IP assets. Now, how is IP planning done and what is necessary to do? Actually, you need to have a dedicated department, part of the legal department, which specializes in IP. Or if you're a small company and do not have huge legal department and thus not, specialized individuals for IP only, then it is very much advisable actually to engage outside consultants, some external providers to help you out in IP planning. IP planning requires to establish clear IP policies and contracts within the company. So if you are a company, for example, which is developing a software, you need to make sure, and if such software, especially if it's developed by your employees, you need to make sure that you have proper IP policies in place and rules which will enable the employer, or you as the employer, to be the ultimate owner of all IP rights over the software that is created by your company. The same, of course, goes for patents and other IP assets that might be the ones that you're creating. Namely, what we see in practice as a common pitfall is that many companies which operate worldwide do have some IP policies adopted on a group level, but which are not very often adopted on the local level. And those companies, for example, include all IP rules in these policies, which might end up not being binding on the local level. So if you intend to implement some group policy on the local level, just make sure that you have done all the procedural steps which are necessary to actually procure that such policy is binding on your employees. For example, in Serbia, if you want to implement group policies on the local level, it has to be adopted by the managing director and then disclosed to employees by publication at a specific place or in a specific document so that they're aware of that policies. And similar rules exist throughout Europe. On the other hand, if you are, for example, developing IP through use of external providers, then you need to make sure that all agreements on assignment and transfer of IP are properly drafted. We will talk a little bit about that later, but the bottom line is that what we see in practice very often is that employers tend to derogate the statutory provisions which deal with transfer of IP rights by their own tailor-made provisions. And if these provisions are good enough, then that's perfect. But very often these provisions are copy-paste, for example, from some US or UK documents, and very often are not sufficient enough to cover everything that needs to be covered on the local level in the country in which you operate. Now, another thing that you need to take care of is IP management, meaning that somebody has to take care of your IP portfolio. Because as we said, the strength of your IP assets and your IP portfolio, of course, depends on the quality of the assets that you are creating, but also from the level of protection that is granted to these assets. And this level of protection greatly actually will affect your ability to prevent others from using these IP assets. Another thing that is very much relevant is monitoring which IP assets your company is in fact using, because according to some searches, like 80% of patents that have been registered are no longer used. And now the question is, do you need to pay fees, for all these protections if you're not using an IP right? The same goes, for example, for trademark. If you have a trademark which is registered in a country in Europe and you're not using that trademark, in most of the countries, lack of use, genuine use for the period of at least 5 years will actually prevent you from enforcing any kind of rights over such trademark and protection that you think you have. And finally, in the course of IP management, you need to make sure that you are not infringing third parties' IP right and exposing your company to claims for damages and other infringement claims. Now, as you can recall from the first slide, once you are big enough and can attract interest, you might want to sell your share, a part of your share, to sell your assets. Or you, being an experienced investor, might want to acquire a share or assets of another company. This is a phase when we engage in the process of due diligence, legal due diligence, but also other types of due diligences. And these processes are conducted not only by sellers, but also by buyers. The sellers, of course, want to make sure that the value of their company is as big as possible, and to prove that the value of the company is big enough, whereby the buyers want to make sure that they understand what the IP assets of a company are and what are the risks associated to such assets. So IP due diligence is very similar to any other due diligence. It's a kind of legal audit which is focused not on the company itself, but on the IP assets of this company to identify which assets are owned, which assets are used, and what are the benefits and risks associated to such assets. And on the following slides, we will just run through some basic issues that we want to identify in the course of each due diligence. First of all, we will always seek to identify all of the IP assets owned or used by the company. Then we will focus on the protection of those assets that are claimed to be owned by the target company, and we will focus on the registrations, priority date, term of protection, scope of protection. Are there any restrictions in terms of time, geographical coverage? Are there any challenges over the assets that are claimed to be owned by a target company? Are there any encumbrances? And those encumbrances are usually listed, actually registered in the local IP offices. Are there any third parties, right? And so on. Then another very important issue in legal due diligence of IP assets is identification of the ownership chain over the IP assets. Now we need to understand who are the authors of the relevant IP assets. Is it the target company or its employees? Is it the target company, but the assets are created by employees and external providers? Or are we dealing with some assets which have been acquired by third parties? So in the course of this analysis, we will of course need to focus on the employment contracts and HR policies which regulate IP assets. And I have already touched upon this issue previously. The bottom line is that whenever, for example, when we have copyrights or patents, most of the regulations in CE and SCE provide that the software, for example, or patents that have been created in the course of employment in execution of work duties of these employees do qualify as the so-called work for hire. So all IP rights, economic rights over these assets actually pertain to the employer unless otherwise agreed in employment contracts or some side agreements. However, as I mentioned, very often these statutory provisions are derogated by some specific provisions typical for these employers. And if you're doing that, just make sure that you focus on what are the requirements under the local law and implement those into the relevant IP provisions in order to prevent a situation in which we have a provision which we, as lawyers, when we read, have no clue who actually is to own the assets which are created by employees and whether any additional compensation to the salary has to be paid to employees. So this is a very important aspect in operation of each IT company, that the employment contracts need to be very clearly drafted and procure the full transfer of all IP rights to the employer. As I said, very often companies have acquired some IP assets from third parties, in which case you need to review the relevant assignment agreements and transfer agreements. And the first thing you need to focus on is the governing law, because in most of the jurisdictions, the transfer and assignment of IP assets can be subjected to a foreign law. If so, of course, the lawyers specialized to practice such foreign law should actually have a final say when reviewing these contracts. But in any case, you need to make sure that all elements for transfer of IP assets under the relevant law are included in the relevant contracts. Depending on the type of the IP asset transfer, the regime for the transfer may also differ. For example, if you're transferring a trademark, you can transfer the trademark application or the trademark registration, whereby if you're transferring a software, you might even transfer the rights over the software which has not been created yet, as long as you do have some specifics in the contract or the corresponding statements of work that will make the relevant software identifiable and therefore IP rights over such software transferable. Of course, what we see in practice very often is also the bulk transfer of some non-identified IP assets, and depending on the jurisdiction, that may or may not be permissible, and this is another thing you need to look into when reviewing IP agreements. Another topic in each legal due diligence are license agreements. So we need to make sure to understand whether third parties' rights have been licensed, properly licensed by the target company, whether the fees have been paid by the relevant companies, whether there are any disputes. And in that respect, do note that depending on the jurisdiction, such license agreements may be registered, sometimes the registration might even be a requirement, but in most of the jurisdiction, registration is necessary in order just to prove, actually to be able to directly enforce all your rights against third parties. Encumbrances, just like in any due diligence, you need to make sure that IP assets are not encumbered, or if they are, just to see what is why they have been encumbered and how you can release these assets from such encumbrances. Another topic in each IP due diligence is our domains, because nowadays we operate very much virtually and domains are very much relevant. And what we have been seeing in practice recently is that whenever there is news that a company will come to a country, somebody registers a domain just to actually try to make, you know, the investor buy that domain from it for some big money. Of course, there are remedies against such actions because such actions are usually done in bad faith. Finally, you need to focus on the proceedings, infringement proceedings. You need to make sure that the target company is not subject to any infringement proceedings, handled by third parties concerning infringements committed by the target company, but also to make sure that actually third parties are not infringing IP assets of the target company that you're interested in. And finally, even though this is not something that lawyers can do by themselves very often, but with the help of other experts like my colleagues from Aon, you need to assess, if possible, the freedom to operate. So does the target company, has means to efficiently run its business on the territory due to others' IP rights? For example, there was a major transaction in Serbia a couple of years ago when the company assets were mainly IP assets, and one of the most important IP assets was actually in problem because there were risks that if it is used abroad, there will be infringement proceedings against it. And that, of course, affected the overall valuation of the company because of that problem with the relevant IP asset. And I'm actually trying to wrap up my presentation. Once we have completed the legal due diligence, the results of that due diligence will be implemented in the SPA. And on this slide, you can see what are the major clauses that are included in each share purchase agreement concerning the results of your IP due diligence. Namely, you will always see in an SPA concerning IP assets or a company operating with IP assets, reps and warranties, which can be, of course, standard and tailor-made. So some of the reps and warranties which are shown on this slide are standard warranties, such as those that provide that the target is a legal and beneficial owner of the IP assets and that IP assets are not encumbered in any manner, that there are no ongoing or threatened proceedings, infringement proceedings or other proceedings concerning IP assets, that IP rights will not expire or terminate as a result of transactions, and that the company has valid licenses. However, if the company is, for example, creating IP solely by use of its employees, of course, you will include a tailor-made rep and warranty, which will say that all IP assets have been created solely by employees of the company, and therefore that all IP rights pertain to the employer. Conditions precedent are another very important aspect of each SPA, and they will greatly depend on the results of your IP due diligence. So depending on what you have discovered in the course of due diligence, you might request the seller to register specific IP assets before closing so that you make sure that the company is a registered owner of all IP assets that it claims to own. However, in a situation in which, for example, we have identified some problems in the IP transfer or IP assignment agreements, similar to the ones that I have described, so that you are not quite sure that all IP over the assets claimed to be owned by the company have actually been acquired properly by the target company. In such case, CP will include signing of specific remedial agreements, which will be aimed to actually procure full ultimate transfer of all IP rights over the assets to the company that will be selling, its assets to you, so that once you acquire the company, you are quite sure that you have acquired all IP rights over the assets claimed to be owned by the target. However, sometimes signing of these remedial agreements will not be really advisable because you don't want to point to a third party that actually they might be owning some rights over the assets that you think you own, which actually in such case the seller will opt for indemnity clause, on the basis of which such buyer, investor, will be entitled to claim damages from the seller in case any of the risks identified in the course of due diligence concerning, for example, the ownership over the IP assets materializes. In such case, the seller will owe damages to the buyer and will have to indemnify it for all risks that have materialized. And finally, post-closing covenants. Post-closing covenants might include specific actions to be performed by sellers in favor of you as a buyer. For example, very often we see transitional agreements concerning use of some IP that have to be signed. But more often we see some non-compete and non-solicit clauses, which are also very much relevant for IP, given the fact that if you are, for example, acquiring a company involved mainly in creation of IP assets, one of the main assets of that company are, of course, employees of that company. And you want to make sure that once you acquire the company, such employees will not leave or will be called by the seller to go with the seller and leave the company, because then you will be in problem. Therefore, we will be including non-solicit clauses. On the other hand, you will also want to make sure that the seller doesn't engage immediately following closing of the transaction in the very same business as you, and this is why non-compete clauses will be included. So this was a very short summary of the main issues that each startup and tech investor should have in mind when engaging in IT business from the legal perspective. And now I will give floor to my colleagues from Aon. George, maybe you can give a short intro on what you will be, guys, discussing in the course of this webinar.
Thank you, Natasa, and thank you for having us in this webinar, because it was a good idea when back in September we discussed about this possibility, because we see also this region very busy with startup activities, IT and software developers, mainly in Serbia, Bulgaria, Croatia, and Romania as well. So it's an interesting region for us from this perspective. So I would pass the floor to my colleagues, because they are the specialists on IP and cyber. And if there is any question related to risk transfer solutions on maybe cyber or something, I can also help. Benoit?
Thank you, George. Good morning. My name is Benoit Geurts. I lead IP advisory in a digital M&A team in Europe. Today, in the digital world, we see increased convergence for technologies and industries. We say that every business is actually digital nowadays. This lead to a lot of new opportunities, a lot of growth opportunities, but also a lot of increased IP and cyber risk. Today, myself and my colleagues will cover 3 topics: IP M&A from a non-legal point of view, the use of IP liability insurance in the context of M&A, and cyber M&A. So first, IP M&A from a buy-side point of view. Aon is a large insurance broker which provided services very much using a lot of analytics. IP Solution has built our own IP analytic platform using AI, machine learning, a lot of data scientists. And this is to allow us to have much more granularity when we look at IP assets. Natasa gave us a very good overview of all the legal IP issues in the context of M&A, but very often in a transaction, what's missing is that the buyers don't always understand the relative importance of IP for the business. They don't really have a good view of who are all the other patent holders in the relevant landscape the company may be operating in. The buyers very often don't have a good view of the relative strengths of the target's portfolio compared to its peers. And increasingly, given that IP is becoming a large driver in transaction, increasingly we are helping investors to try to actually understand the real business impact and all the insights related to IP. So we have built some proprietary tools. We have a platform which is not sold as a third-party tool. We use it to provide insights and data to our consultants. And it allows us to do things like, for example, on the left here, we have a way of actually assessing patent strengths. You know, it's very clear that to really understand the value of patents, patent attorneys need to actually read the legal document. They need to read the patent claims. But if you are looking at trying to understand the strengths of patents in a very large patent portfolio of maybe hundreds of patent assets or maybe even thousands, if you want to compare it with other companies, you need technology to do that. It's not perfect, but it's good enough to give you a high-level picture. So we are able to, for example, in the top left here, we're able to highlight the likelihood of validity for patents, and we have a proprietary algorithm to do that, and also the likelihood that a patent may be infringed. And you know, the best patents are the patents which are valid and likely infringed by competitors, because you could potentially license these assets and generate additional income. We also look at trying to understand the landscape and cluster the patents based on technologies to understand, if you want, the IP market share of the various companies in this space in the relevant technology clusters. And sometimes it's very surprising. You may have a company very strong in a market, but actually in some of the main enabling technologies, they may be very weak. And some very large companies who are not directly competing against the business in the marketplace may have very relevant IP assets, which could potentially lead to demand for licensing fees later on. Think about companies like IBM. IBM have got patents in every single technology. And sometimes, you know, it's very surprising to see the number of patents which have been filed in a new field a few years before. And it's very clear that as soon as the business will start to make money, IBM will come and ask some licensing royalties. This is what happened with Twitter, for example. When Twitter announced their flotation, they were effectively forced to buy a portfolio from IBM, which was very relevant to their business. On the right here, you see what we call the benchmarking chart, where we measure the quality, the quantity of patents in a company's portfolio. Next slide. We have a process to help investors understand the importance of IP and the strengths of IP. We call it CORE, C for coverage, which is the protection that the IP is actually giving to the business. And to do that, we look at you know, how closely aligned the IP assets are to the business. We look at the geographical coverage of the IP assets. We also look at the breadth of claims of the patents, because this is the really true protection that patents give to the business. We also look at opportunities. As Natasa said earlier, sometime when you acquire business, you have a lot of IP rights, but actually many patents may not be relevant to the business anymore. The business may have evolved. The acquirer will incur a lot of liability, a lot of maintenance cost to keep all these patents, and there may be an opportunity to find some cost reduction by abandoning some of these assets, or maybe even selling them to another company. There could also be opportunities to license the IP into adjacent markets and realize additional revenue. And then obviously risk is a very important factor, mostly the key thing to look for in a non-legal due diligence. We built patent landscape for our report, and we look at all the litigated patents in this landscape. And in our tool, we have ingested the largest data set of patent litigation data in the world. So we are able automatically to find all the litigated patents, the result through the litigation actions. Also, we can identify if they were operating companies or what's called non-practicing entities, or sometimes patent trolls. And it can give you an idea of the likely scenario of some of these patents in the future years. If the target company has a couple of competitors who have been sued in the last 2-3 years, it could well be that the target may be next in line. And we provide this kind of non-legal report very much through charts, dashboard, to enable investors to understand the business side of IP very, very quickly. Next slide will show you a case study. This was for a company. It's obviously anonymized, but it's for a company from the smart city industry, tech sector. This company was quite strong in Europe, with a great business, growing quite a lot of deal with various towns across Europe. It's all to do with traffic flow, parking management. But actually, when we built the patent landscape, it was very revealing to see that there was a lot of IP floating around. Many companies had been filing patents the last 5 to 10 years. And this was going to create a problem for the business. It was particularly concerning to see that in some key clusters, the company had very few patent assets. So while it's important to have high quality patent assets, you also need a certain number of patent assets, because when companies are sometimes demanding a license, that you take a license, having sufficient assets allow you to cross-license and maybe avoid having to pay royalties. So this was very insightful for the clients, and we base this landscape on machine learning model that we built with IP analysts. So this is for the buy side. I'd like now to talk to you about what we do for tech startup as well in the context of M&A. Next slide, please. So when they want to try to raise finance or maybe sell the business and prepare for exit. We have realized that too many times when you have a company trying to raise capital, it's very difficult to actually articulate the IP story and position IP as a value driver. IP is a legal right, but actually it's also a business tool. And to actually tell your IP narrative so that the M&A executives, potential investors, understand why they should really consider IP and probably increase the valuation of the business based on the IP, is very difficult. So we've built a service which is called Quality of IP, which is a sell-side report, and we work alongside investment bank to prepare this report, which will sit in the data room. And it provides basically a very clear inventory of all the IP assets, but this inventory has been segmented to match the various product lines, showing clearly the relationship between the IP and the revenues and the profit potentially. We score the IP assets using some of our algorithms, and we show how strong the IP is compared to some of the competitors. We also want to make sure that the buyer would understand the litigation situation. So we show if some of the IP assets have been maybe asserted in court and if they've survived potential legal challenges. So we clearly provide an IP story to bring the conversation with potential buyers. And we include not only patents in these type of reports, but we also look at trade secret and know-how, data and software, and trademark and brands. And next slide, please. The benefit of this kind of service is that it clearly enhances the company positioning. It will bring the discussion of IP very early on in the M&A process. Too many times, unfortunately, IP is considered only right at the end of a transaction where legal advisors become involved, but actually it's a business matter which should be brought in right at the beginning. When we do some of these chart and analytics, for example, a patent landscape, one of the benefits is also that we can sometimes find additional potential buyers, strategic buyers, where we can show the complementarity between the company's portfolio and maybe some of the large strategics. And hopefully these kind of reports can facilitate the tasks of colleagues like Natasa's team when they do the legal DD as well. And if you go to the next slide, please. This is just a highlight, a cell site case study. This was we did some work for a medical scanner company. So we first started to build a landscape which included not only the company being sold, but also all the competitors. And it included some very large companies, but we were able to actually filter their portfolio to only compare the relevant patent assets and not the huge portfolio, which had thousands of assets. This was using some of the machine learning models that we have. And what we wanted to show here is that actually the company in question, which is called example here, had actually the largest number of very relevant patent assets. It's a niche positioning for this type of medical scanner. So they were actually dominant in numbers, but also if you look at the bottom right, they were also clearly leading in terms of quality. So when we measured the actual claim breadth of the granted patents from this company, they were much better than even the large incumbents. So this was a really nice positioning for the company, which shows that actually if one of the large incumbents wanted to buy this company, they not only would buy a lot of really good technology, but very strong patents, which would fit very well with their own large portfolio. So I hope it gave you a nice overview of what we do in IP M&A from a non-legal point of view. I'd like now to hand over to my colleague, Rebecca, who will cover IP liability insurance in the context of M&A. Thank you.
Thank you, Benoit. In this section of the webinar, I'll talk briefly on the importance of IP risk transfer in the context of M&A. So next slide, please. So around 9.6% of companies are being sued for IP infringement within 2 years of acquiring another company. Companies in networking, communications, and computer electronics industries experience a higher IP risk. More than 25% of acquirers in these industries are sued for IP infringement in the same or following year of engaging in M&A. Please do note that analysis is limited to companies with headquarters in the US. Whilst in EMEA, the percentages are not as high, we suspect that the trend is similar from an industry perspective. Next slide, please. For acquiring companies, the risk of IP litigation increases in years closer to M&A and remains high thereafter. The highest jump is observed in years just following the M&A, where the chances of being sued surges by 17%. And this is in comparison to annual average, where around 1% of US domiciled companies are sued for IP infringement. Again, note that the analysis is based on companies headquartered in the US, but in EMEA, the jump may not be as steep, but there will likely be an increase for companies undergoing M&A nevertheless. Next slide, please. So how can IP insurance help with the transferring of this type of risk? IP insurance can be utilized to cover the policyholder against third-party IP infringement claims made against them. it will reimburse the policyholder or the acquiring company for legal expenses, settlement fees, or damages incurred, and can also extend to cover trade secret misappropriation. The insurance will also kick in prior to a full-blown litigation and can cover the legal expenses of settling things out of court, such as during mediation or arbitration, and will be triggered at the point of a warning letter. As Natasa has alluded to earlier as well, another risk that can be covered and purchased by acquiring companies for insurance is contractual indemnities, which is typically identified in M&A transactions from reviewing the target company's commercial contracts. So oftentimes legal due diligence will reveal that there is an IP indemnity in place, which is becoming increasingly common, especially in highly innovative industries such as the tech sector, which can also be found to be uncapped. And what this means is that the target may be required to identify their customer if, due to the use of the target's technology and products, they are sued by the third party for IP infringement. Whilst the insurance covers the cost of these clauses, it can also be used as a business enabler and help the target company secure future contracts down the line, as they know that they can offer a high IP indemnity in comparison to their peers. And finally, IP rights protection coverage can also be used to protect the acquiring company should a third party try to challenge any of their newly acquired IP rights via, for example, an invalidity proceeding. For startups, there is also an offensive cover available, which can cover their cost of litigation should a third party be found to be infringing on their IP rights. And other benefits of the insurance policy is that it can be on a worldwide global coverage basis, so that if there are any new acquisitions made by the acquiring company in a separate jurisdiction, then this can also be covered. It can also extend to all business activities, or can be limited to specific acquired companies and also the contracts within the target company's portfolio. Finally, the policyholder has the choice of counsel and they can appoint to represent them. I will now pass on to Nathan to talk about cyber in the M&A context. Thank you.
Thanks, Rebecca. Yeah, good morning all. I'm just really conscious of time, so this will be a bit of a whistle-stop tour through the sort of importance of cyber M&A. And before I sort of go into the real sort of detail, I think it's important to know that you know, Aon is very well known as a brokerage organisation, but we also have our own global cyber business. So I'm not an insurance person. I'm one of over 800 cyber consultants that deal with cyber risk across the M&A lifecycle, including due diligence, investor ownership, and exit. Next slide, please. So I've only have one slide, and I just wanted to sort of kind of paint a picture of the differences between IT due diligence, tech due diligence, which seems to be a fairly new kid on the block, if you like, and cyber due diligence. So historically, IT due diligence is quite often done within the context of an acquisition, and that very much looks at things like the systems and software that are in place, its relevance, its performance, the capability of those systems, but also the investment that is needed. What it doesn't look at is tangible risk. IT due diligence is growing into what is more commonly known as tech or technical due diligence, which kind of does all of the same as IT due diligence, but it includes things like source code. So it's grown into a more holistic technical view. But again, it doesn't look at tangible cyber risk. From a cyber DD perspective, and of course there are synergies with tech and IT, and in some cases overlap, but a true cyber due diligence should be looking and assessing tangible cyber risks that are out there across the surface, deep and dark web. The context, the surface web, as we all know it, we use it every single day, either via our business email or on our own laptops and PCs at home, when we're doing things and like searching for advice, guidance, shopping on search engines. What we're actually only doing is exposing about 5% of all of the data on the internet. That is known as the surface web. The remainder of the 95% of information is held within the deep and the dark web. The easiest way to explain that is if you think of the surface web, the 5% that we all use on a daily basis, as a structured library of information. Everything is structured in terms of genre, in terms of sector, in terms of country, etc., etc. It's easy to find. It's easy to get to where you want to go to in terms of looking for that data. The remainder of the 95% in the deep and dark web is completely unstructured. It's very difficult to navigate and it's very difficult to find the information. But that is where hackers do their business. What a cyber due diligence will do will expose and explore those risks and look for tangible threat intelligence on the deep and dark web and assess how that affects and how that is relevant to target organizations. What we generally do is include the target, any senior management, but also its country of operations and sector. So high tech is a high risk organization. So we're looking for any information that we can find on the deep and dark web that leads to things like historical threats or historical hacks that have not surfaced. A successful cyber attack is one that hasn't surfaced. It's one that's not known until the hacker wants the organization to know. And this can be done via various ways, ransomware being the most popular and still remains the most popular method of cyber attack, but also things like denial of service and theft of data. What doing cyber due diligence will do will provide those threats and intelligence and that tangible data to understand if there are historical breaches or if there are threats or intelligence around threats. We call it chatter, where hacking forums, either opportunistic or state-backed, are looking at a specific sector, looking or being more active in a specific country, or looking at a specific target. And by going into this, where the hackers do business, we're able to assess and extract that information to provide real tangible risks and real tangible data. What we also do is we will look at vulnerabilities that are faced in the internet. And again, IT and tech due diligence won't do that. All organizations have a digital footprint. All organizations use the internet, particularly within tech. What a cyber due diligence will do, it will look at all of that traffic that has been communicated across the internet or the surface web, and it will look for vulnerabilities. And those vulnerabilities are routes in that hackers could exploit. That could be software that is not patched. It could be weak encryption methods. It could be, infected systems. If it's communicated over the internet, then a cyber due diligence will be able to find them. Also, going into a deeper dive, a cyber due diligence will look at how the system is set up or how the organization is set up to respond and recover from a cyber attack. So what systems, policies and procedures are in place to protect themselves, but then what systems, policies and procedures, particularly from a management and a governance point of view, are in place within that target organization to help them respond and recover. The real costs from a cyber attack come after the event, when you're trying to get systems back online, when you're trying to get backups data into a usable format and into usable state. That is what takes the time, and that is what costs the money. Clearly, the interactions between IP and cyber go hand in glove, but they're quite often overlooked. Protecting IP from a cyber attack, including methods like counter eavesdropping, are a very specialist area and are quite often overlooked. IP is often looked at, protected by legal mechanisms, not from a cyber mechanism. So within Aon, we work closely as a team to make sure that both IP and cyber, where we can, are looked at together. I'm really conscious of time and I want to leave some time for questions, but I'll just give you a couple of examples of some of the things that we found recently within cyber due diligence. So on one recent project, we found that the target organization was actually being used, unbeknown to them, to stage denial of service attacks across its supply chain. On another target, we found out that senior management were involved in criminal activity, that had not been exposed. And on another target, we found that the supplier had inadvertently leaked pretty critical network designs drawings that were very sensitive onto the deep and dark web and were being discussed via various hacking forums, which fundamentally devalued the target organization. Clearly, I could talk about this for much longer, but again, I'm really conscious of time, and I want to allow time for questions at the end. So I'll stop there. Thank you.
Thank you, Nathan, and thank you, Benoit and Rebecca as well. This was very informative, even for me, who does many of IP due diligences. One question from my side, I mean, how do you see, I mean, do you see a significant growth in IP insurance policies in your practice? Because there was a time when nobody was insuring, you know, IP, and nowadays, I guess the situation has changed. There were some recent information that, like, in the last decade, I mean, the growth in IP insurance has increased by 300%. I mean, what is your view on that? Are there like regions where this is very much customary, and then some, like probably Southeast Europe or this region where this is less customary?
Yeah, but go on that one. So yes, we've definitely seen increase in uptake in purchase of IP insurance. And I think with underwriters as well, the markets are getting a lot more comfortable with IP insurance policies. There's a lot more claims information available. There's a lot more data just available in general on a lot of different types of companies and industries as well. This has led to, you know, improved retentions as well, increased limits available in capacity and appetite in the market. I think a lot of times in terms of jurisdictions, we're definitely seeing EMEA clients talking about this to us a bit more. I think there's also a fear, especially if they're looking to expand into certain jurisdictions like the US, then IP insurance policies are always on their mind.
Yeah, thank you. And I guess the situation is very similar with the IP infringement cases, because depending on how, you know, how well aware, you know, persons within a country are when it comes to IP asset, it depends, you know, how much in IP infringement cases we see, because our experience is that in Southeast Europe, they're less customary. On the other hand, you know, in Western Europe, especially US, this is quite a big deal. And based on your, Rebecca, slides, that appears to be the case with your findings as well, I would say.
Yes, absolutely. Yeah.
Nathan, because this cyber thing is for me very much interesting, is there anything else you can say about this correlation between IP and cyber? I mean, you did say a lot, but maybe for everyone, because this is quite a new thing.
Yeah, I mean, yes, we know we need to be quite careful about what we say on this call, but quite often, you know, cyber. When cyber due diligence is carried out, it's looked at protecting this sort of corporate environment, you know, in terms of corporate websites, corporate email addresses, etc., etc. What is often not understood is how cyber can protect and defend its you know, a company's IP, and that may need some very specific requirements in terms of how the data is hosted, in terms of where it is, you know, both on-prem and within data centers. You know, quite often there may be a need to segregate it completely. You know, there are vulnerabilities that can be exploited from an eavesdropping point of view. So being very clear on where the IP is, how important that is, and making sure it's segregated from networks and indeed other electromagnetic systems is really important.
Just to add to this, we see very often now in transaction, trade secret is becoming actually the most important category of IP assets, and trade secret can directly be a target of cyber hackers. So when you know, when you do some due diligence on IP assets and looking at trade secret, it's important to involve the cyber element as well.
Good. Well, I think that we have quite a shy audience, so we haven't received too many questions. I would suggest everyone who was attending this webinar to feel free to contact any of us directly in case there are any questions that have not been answered. It was really a pleasure to host this webinar and to be able to share our views on IP protection with all of you guys. So from my side, that would be all. I would wrap up this webinar and just feel free to contact any of us from Wolf Theiss and Aon.
Thank you very much.
Thank you.
Thank you.
Bye.
Thank you.
Thank you.
Thank you, everyone.
Bye-bye.